All right, good afternoon, everybody, and welcome to RASM's Legal Tax Ramifications to Buying and Selling as a non-USA citizen. So we're going to go ahead and kick this session off. We're going to have two lovely speakers today, Mariana Parkin and Joanne Coots. So I'll let you guys go ahead and take it from here.
Sounds good. Thank you so much, Cassidy. This is quite an interesting subject, and maybe I guess we'll let us mention a little bit about our firm. We, as a CPA firm, Coons & Parkin, and our sister law firm, Coons & Associates, we focus a lot on the real estate side of things, so real estate tax and business. So a lot of this non-resident foreign ownership and buying and holding and selling sort of comes on both the legal and the tax side of our business. We do quite a bit of tax work for the non-residents that are buying property, renting it, selling it. And I will tell you something, that the rules may stay very similar, but the circumstances and how they're applied and how IRS is treating them seems to be a constant battle of changes and struggles, particularly in the last year, where these poor people were stuck overseas, or on the other hand, were stuck here in US and had difficult time to get access to their information, and you know, getting ITIN, for example, created different challenges. So we will get into kind of a step of all of these different circumstances, but just wanted to let you know that's kind of our background in terms of dealing with the non-residents. So we help them out along the way. You know, they come in the country. We often meet them through them purchasing a real estate property, and Joanne is sitting across the table from them doing the closing, and she says, you know, what are you buying this for? And they say, oh, I'm going to rent it. In fact, they already have a tenant lined up. And Joanne's rolling her eyes and says, oh my God, have you done all of the things that need to be done in order to get this set up? So today we have just kind of one session where there's quite a bit of topics to cover. I also wanted to say that Joanne and I have done webinars on a separate piece of these topics. For example, we've done things on FIRPTA, we've done things on ITIN, we've done things on rental income and of the non-residents. So we encourage you to also take a look at our website, coonsandparkin.com and coonsassociates.com. And we have our webinars recorded as well. So if you do need further information, we encourage you to check out those webinars. We also have a YouTube channel as well. And a lot of that information is there. And people tend to Google. So sometimes you find some useful stuff, sometimes not so much. So I think today the way that I would like to organize the information that I want to talk about is sort of in stages of these foreigners coming in and buying. You know, the title of this class is Buying and Selling as a non-U.S. citizen. So I wanted to also jump in and say buying, holding, and then selling. And then it's further complicated by what kind of property is it? Is it just for their personal enjoyment, or are we talking about it being a business property? So let's kind of start out from the beginning. Before we even get into the property part, let's just touch on the whole non-USA citizen, there's a little bit of the confusion that I wanted to clear up. There is the non-citizen and the resident concept can be intermixed for this purpose, but they're a little bit different. What you guys really want to know is a non-U.S. tax resident. That's really the people that you're here to listen about. And the non-U.S. resident is somebody who really has a tax home outside of U.S., and they are coming here with the purpose of, buying and holding maybe an investment property or personal use property. You also have a situation where these individuals may be moving here, in which case they start out as a U.S. non-tax resident, but then they establish U.S. residency. Once these people establish U.S. residency, either by obtaining a visa and they buy a business and they're here over a certain number of days, then the rules of the non-resident do not apply to them anymore. Then they're treated as a U.S. tax residents, and things like ITINs and FERPTA and all of those terms that you hear about no longer apply to these individuals. So we are really focusing here on particularly the non-residents, again, people that are not trying to establish a tax home in U.S. They're really here to buy property, hold it, and then sell it, or pass it on, or things like that. So that is a kind of a weird concept in itself. The other thing that can sometimes be confusing is how many days the individual spends here. So technically, once they're here over 180 days in a year, they default to being considered a U.S. tax resident. But there's also treaty provisions that we can invoke to say that that person still has a tax home outside of U.S. This is definitely beyond the scope of this. So I just wanted you to sort of have an idea of who is considered a U.S. tax resident versus U.S. non-tax resident. So let's just focus on those folks that are really meaning to come in, purchase the property, hold it, and then sell it. So let's start out of the gate with a distinction of what kind of property these individuals are planning on buying. Is it going to be their personal use? So it's vacation, this is Florida, everybody wants to be here. We found for a lot of the non-residents that come here, they either hear Siesta Key or Disney World. There's really nothing in between. So it's funny when they come here and they meet a lot of the realtors, a lot of you guys, and then you start driving them around Sarasota, and then they just fall in love. And then now you see, I have a lot of clients with rentals on Lido Key, and they're kind of all over in Casey Key as well. So they are coming in here and they want to possibly buy a house that they will come with their family and stay as a vacation home. They're not planning to rent it. They're just planning to use it personally and then hold it and kind of see where it goes. And then of course we have the other choice, the other option of people who are coming in and buying the property with the intent of renting it, making some money while they're renting it, and then also selling it. So where the distinction is going to be in our discussion is what happens with the rental income. But at the beginning, let's start out with the first initial step. So the individual is buying, this non-resident is buying a property. The first question that we always get is, do I need an ITIN? What is an ITIN? ITIN is their identification number in US. And the ITIN really identifies them in front of IRS. So if they have any tax dealings, filings, implications, and stuff like that, they need to have some sort of number to identify them in front of IRS. And that's called an ITIN because they don't have a social security number like US residents do. So the first question we get is, do I need an ITIN? Well, it's interesting because whether you're buying a personal property or you're buying an investment property, you actually don't need to have an ITIN at the beginning. When we start dealing with the rental income, and we'll talk about that, then the ITIN is definitely needed. But if you are buying a property and you say, well, you know what, I'm gonna hold it and then I don't know what I'm gonna do with it, just in case I sell it, can I go and get an ITIN just ahead of time or as preliminary, or I'm here in US anyway, so can I get an ITIN? In the past, you used to be able to send in an application and copy of your passport or go to an IRS office. However, IRS has become very, very strict in handing out those ITIN numbers. So for these individuals to get an ITIN number, they actually need to have a reason to have an ITIN number. Purchasing the property is not one of those qualifying reasons, because just by buying the property, they're not automatically starting to generate income. So until such time as either they're planning on generating rental income or they're already planning on selling it and there's a contract for sale, there's really no IRS approved reason for them to get an ITIN. So sometimes they'll you're their first point of contact. So they'll say to you, hey, can you, hook me up with an IRS appointment and I'm going to go get an ITIN, or show me where the IRS office is, or let me talk to CPA. And they do not need an ITIN, and they cannot get one this early in the process. So they're buying the property. So then becomes, so let's say this property is going to be their personal use. They are buying it, they are going to renovate it, they're going to, improve it, do something to it, and then they're just going to use it as a vacation property. Just them having a property in US that they're using as vacation does not create a tax return filing requirement for them. Okay, so that's also very important to understand. These individuals come in, they're really scared of IRS because it's a government agency and it's taxes, and everybody thinks they're going to IRS jail immediately. So you're going to get a lot of questions from these guys like, oh my God, what do I need to do? Do I need to file? How do I need to identify myself somehow in front of IRS? And essentially just having a property that is used personally does not create a tax filing requirement for them. So they can have the property here for years, use it as a vacation, never have to file a tax return. Again, beyond the scope of this particular class, but if they do get into the whole thing of, hey, we're going to be here over 6 months, that can set off a little bit of the, your ears are ringing now, and you say, hey, you got to talk to CPA, because that 183 days is where they may have to have a filing requirement just to tell IRS that even though they're here over 180 days, they still are not considered US tax residents. So that gets a little bit complicated. But if you do hear of somebody who is maybe planning on retiring, or somebody whose kids may go to school here, and then let's say they're here for IMG, the husband is back home running the business, the wife stays here with the kids. Does the wife have a filing requirement? She does not have an income. Probably so, because she will be here over 6 months, but her filing is going to be fairly straightforward, because we'll have that treaty exemption to say that although she's here over 180 days, she's not a US resident, she's not generating any income here. So for your guys' purpose, when you meet them, just keep your ears perked up for kind of the number of days discussion, and to say, if you're here over 6 months, talk to a CPA, but generally speaking, they don't need to get an ITIN until they have to file something, and they're good to go buying this property. So then let's get into the situation of where what they're buying is a rental property. So their plan is to start renting it, even if they rent it part of the time that they're not here, and then when they're here, they're enjoying it. Personally, that's great. If they're planning on putting that property in rental use, that gives them a reason to get an ITIN. And they should definitely get an ITIN while they're here. It's a lot more convenient to be able to go to IRS office with the paperwork and be able to get an ITIN. Here is the kicker with getting an ITIN too early in the process. Remember how I told you that IRS needs to have a reason why the ITIN is needed. So just your intent to put the property for rent is not a good enough reason for IRS, because you don't have any rental income coming in yet, and you don't really have anything in place. You don't have a contract. So again, that's going to be a little bit too early to go and apply for that ITIN. However, if you sign on with a property management company, or there's going to be somebody else who's, maybe one of you guys handle the rentals for them, if there's a contract to say that this is my property and I'm going to put it up for rent, there's typically a letter that a property management company can write to that individual to say, hey, this property is about to be rented. We're going to report this rental income to you. We need you to have an ITIN for the records. Having the contract signed and executed with a date, also having that letter from the property management company, has worked for us in the past to be able to go to an IRS office and for that person to get an ITIN number. It is, again, you're establishing intent, and it's clear, not like, hey, I'll, rent this property next year. I am renting this property right now. There's a property management company in place and stuff like that. So that is also very important. And the reason why I kind of focus on the timing is because, like I said, it's easier if they're here and they're at closing, or they're trying to get this property set up for rent, that they make an appointment and go to an IRS office. Another alternative to going to an IRS office is going to a certified acceptance agent. So a certified acceptance agent is likely another CPA, and some of the firms have somebody in the office who's a certified acceptance agent. So that individual basically serves a little bit in the capacity of entrusted IRS agent, if you will. What the role of that person is to get a copy of the passport for the non-resident and certify that that copy of the passport truly represents the actual passport, and it is the copy of the passport that belongs to this particular non-resident. Please make a note, and this is extremely important, that certified acceptance agent is not a notary. Notary is somebody who can notarize copies, and not, everywhere you go when you do closings and stuff like that, you need a notary. This is a notary like individual that kind of serves in the capacity of an IRS agent. So this works particularly for IRS purpose and specifically for the I-10 application. So again, if they don't go to IRS directly, they can go to certified acceptance agent. Since I'm on the subject, let me also mention that, again, in COVID time last year, where a lot of these individuals couldn't travel to US and they couldn't do the application, that I-10 application in person, they had a couple of other choices. They can find a certified acceptance agent back home. We found that a lot of times big firms back home, if somebody lives in a big city and there's like a KPMG or Ernst & Young, there's going to be somebody there who is a certified acceptance agent. They can do the same thing. They can meet with them there. They can certify a copy of the passport. They can send it here and we can complete the I-10 application. So that was one of the choices. The other choice is to go to a passport issuing authority back home. And typically that office can issue a copy of the passport that is basically certified and that it gets accepted by IRS. In Europe, I didn't see much success there, but I know my Canadian clients, they're able to go to Passport Canada, and Passport Canada issues them a specific copy that says this copy is issued by the original issuing authority. It seems a little bit redundant, but it's essentially a way to work around and not have to send in your original passport to IRS. So when they go to either the certified acceptance agent or they go to the original passport issuing authority. So this is the options if they're not here. What happened in COVID, again, when everything was shut down, the passport offices were shut down, a lot of those firms were shut down, IRS actually allowed for the certified acceptance agents to perform the interviews over Zoom. So what was required at that time is that the non-resident still sends their passport, their actual passport, to that certified acceptance agent's office. They schedule a Zoom meeting, and then the certified acceptance agent meets the client, and then they certify the copy of the passport, and then that copy can get attached to the I-10 application. So there's a lot of hoops to jump through. Hopefully now, I think the IRS office is kind of slowly reopening again, and hopefully with the travel being allowed again, and these individuals coming in US in person again, that things are going to flow again in terms of the I-10 application. But it's been extremely, extremely challenging for the individuals to do that. But Zoom with a certified acceptance agent has definitely been an option. So that was kind of a little side story, just to, again, highlight the importance of what it is like to get this I-10 number in US. So how does that impact you guys? Again, when you were working with a non-resident and, your ears perked up to their situation and they say, what are you going to do with this property? And they say, I'm going to buy this property, I'm going to rent it out, I'm going to be here getting it ready. That's kind of an immediate call to action to say, you better talk to a CPA to see if you need to get an I-10. Can you get the I-10 now? Talk to the property management company, get that contract going, and then you can have the contract, you can have the letter, you can go to IRS, and you can get an I-10 number at least the application in. And as you know now, IRS is so behind that the sooner you can get the application, the better, because they're still going to take months and months and months to process it. So, so having said all of that, so let's say the individual has an agreement with a realtor or property management company for rent. They went and they got their application, and then what happens then? What is their, what do these non-residents have to do with that rental income? So the idea here is that when they earn that rental income, two things happen. They the property management who pays them the rental income serves as an agent, because they collect the rent from the tenants, and then they turn around and put that rent in the account for this non-resident. So as an agent, the property management company is obligated to withhold, because they're paying to a non-resident. And IRS says that any payments to a non-resident are subject to withholding, and the rate is pretty high. And these are periodic payments. I believe the rate is something like 30%, if I'm not mistaken. So it gets really costly. The non-resident then, when they ultimately do file the tax return, can get that withholding back. That's in excess of the tax, but it can still get pretty, kind of costly to have 30% withheld from every rent check that they earn. So the property management company typically will have these non-residents fill out a form before the rental income starts flowing. And that form, it's W-8, will basically tell the property management company that a non-resident is electing to treat this rental property with the rental income and expense as a business in U.S. Once they make that election and the property management company has that election on file, then they no longer have the responsibility to withhold the rental payments, but the non-resident now has the responsibility to file a tax return every year, report the rental revenue, claim the rental expense against it, and then pay any tax that is due with it. So let's kind of stay here. So the non-resident, when they come to my office and we say, oh, great, you've got a rental property, and now you're obligated to file, everybody immediately gets scared. Again, everybody thinks they're going to IRS jail, and they say, oh, if I need to file an IRS, I have all of this other income. The kicker here is it's very important for them to understand that even though they have elected to treat U.S. rental property as a U.S. business, they are not required to report any of the other sources of income earned outside of U.S. So as a non-resident, you're not obligated to report on the U.S. tax return any of the other sources of income outside of U.S. Your only obligation on the U.S. non-resident tax return is to report U.S. source income, and then claim expenses against it. So after we calm them down and we say, this is what you have to do, there's a bunch of forms to fill out, again, depending on how many days they're here and if we're taking a treaty exemption. But let's kind of talk a little bit about the rental schedule, which is what they're going to be asking you about. Can we deduct expenses? And the answer is yes. Once they file that election that they're treating this rental property as a business, they can now take all sorts of expenses against the rental income. The expenses that they can take are the same expenses as a regular U.S. resident can take against the rental income. So you've got your property tax, you've got your, if they borrow money, let's say here, then you've got your mortgage interest, you've got your house insurance, repairs, maintenance, improvements, you've got association dues, you name it, all of the rental expenses. In addition, and this is also very important for you guys as you talk to them, if they're coming to check on the property, we can also capture a big chunk of their travel costs that they incur because they're coming here from their home country to check on the property. Now, we want to be reasonable, and if they're coming here 3 times a year and they're bringing the whole entire family with them, we may not be able to deduct all 3 trips for the entire family. So to be reasonable, we want to say how much of the expense, the travel expense that's incurred is really for the trip. Well, maybe one of the trips, or maybe we take, half of each trip and say one half is related to your personal visit and maybe half is to check on the property. So we kind of try to be reasonable and not push the envelope too far, because the last thing we want to do is have this tax return to IRS with the rental income and expenses against it, and your biggest expense is travel, which really makes no sense in the rental property. Your biggest expense should be depreciation and repairs and maintenance and property tax. So we kind of want to make sure that whatever expenses we take are reasonable, but we definitely want to make sure that we capture everything that's available. And specifically for the non-residents, their travel expense can definitely be captured. The other thing, if they don't have any other place here and the property that they own is rented and they do need to rent a car or stay in a hotel or something like that, again, we want to use some sort of reasonable allocation method for them to capture those expenses. So what happens is we prepare the tax return, we've got the rental revenue, we've got all the rental expenses. We also have to start depreciating the property. I want to kind of go a little bit sideways on the whole concept of depreciation. I can't talk enough about it. We also did a class on just the rental property, resident or not resident, it really doesn't matter. But one of the things on the depreciation is, they say, hey, if I'm going to depreciate my property, if I'm going to take this depreciation expense, well, it's not going to reduce the cost of my property. So when I ultimately sell it, my gain is bigger. Well, the answer to that is absolutely, that's correct. The depreciation reduces the cost of the property, and then when you have to calculate the gain, it's the reduced cost of the property versus the sales proceeds. However, IRS makes you take the depreciation. In fact, if you don't take depreciation, you're going to suffer at the end when you sell the property. When you go to calculate that gain, the way that IRS is going to force you to calculate the cost of the property, it's as if you took the depreciation, even though you didn't. So the IRS is not going to bounce the return back to you to say you didn't claim depreciation. They really don't care. But when you go to calculate the gain, they're going to make you take the depreciation as if you had taken it. So your gain is going to be your gain anyway. It's one of those funky rules with IRS, go figure. But the gain is going to be your gain. But in the meantime, while your property was being rented, you did not get to claim that as an expense. So you lost out, and now you're, paying tax on the gain anyway. So just as a side note, because I think a lot of the countries have a similar type of, I know in Canada, they do have a similar type of allowance for the write-off and the cost. And so when they, kind of look at the expenses and they give me a very organized record to say, here's my expenses. When they look at their tax return, it's bigger because there's 10 grand of depreciation. We typically get into this discussion of, do we have to claim it and why and stuff like that. So that's kind of a little side note on that. So let's get back into, now I've got my rental income, now I've got my rental expenses, now I have a loss, right? So my non-resident client says to me, well, you know what, I've got a loss and I really don't care. I don't really need to file in US because I've got a loss. So can I just skip filing, or, it's really not that important. The key is that you still need to file because you are generating revenue in US. You are, you've told your property management company that you're electing for this to be your business. So you do need to file, you need to report the rent. Of course, IRS doesn't care about your expenses, but you still need to be as diligent to maximize your expenses in the year of losses as you are in the year of gain. And the reason for that is following. The losses that you generate every year are not lost. They carry forward. So you're establishing a loss carry forward schedule as a non-resident, because again, this is the only source of income you have in US as your rental property. You've got your loss carry forward schedule. When it's time for you to sell this property, 10 years later, the property went up in value. Now you've got a gain. Aha. But now you've got these cumulative losses that you have been tracking on your tax return. And now, when you've got that gain, you can use these cumulative losses against the gain. It is absolutely critical. When I've got a non-resident selling a property and they come to me because now we have to deal with the sale, the first thing I ask them is, show me all of the tax returns that you filed. And I look at the tax returns and I look and see if they've got those cumulative losses, because that sometimes saves them quite a bit of money. So if you are a non-resident and you haven't filed in U.S. to establish your losses, you can't say, oh, you know what, I had losses for all these years that I had this property, so can't I just use that? You cannot do that all in 1 year. You actually have to go back and file the tax returns for every year of rental to get those losses on the books. So you have to create that carry forward schedule every year in order to show IRS that you do have these cumulative losses. And then you can use those losses against the gain. So I guess for you to remember, when you guys are talking to these foreigners that are coming in here, they're buying the rental property, you want to listen for that, how many days are here. You want to listen for that it's going to be a rental. You want to listen for that they don't have an ITIN from their past dealings and now they have to apply for one, and that they may have to file a tax return in the U.S. And please talk to a CPA about their need and requirement to file. So you're not supposed to hand out the tax advice, but when you hear a lot of these terms, this is kind of a way for you to say, hey, you may have to have a filing requirement in U.S. and you need to check with somebody. So now that brings us to the sort of the final stage, which is the selling of the property. And again, you guys can be involved with the same person when they bought it and they're selling it, or you are going to be the listing agent for them, or you may have a client who is buying a property and the seller is a foreigner. So you can come across these individuals in a variety of ways. So comes the sale. And the sale, let's also talk about the sale of the property that was not a rental, so it was just a personal use property, and then sale of the property that is a rental. So let's talk first about the non-rental. So like I told you guys, let's step back a few steps and say, if it was a rental, if it was a personal use property, remember they never had to get an ITIN. Right? So they were just coming in the country, they're enjoying their vacation home, and now they're selling it, but they don't have a tax ID number in US because they've never had to file a tax return here. Well, now comes the sale. So what happens in the sale is a foreigner, when a foreigner sells US real property, there is this concept of FIRPTA, and we've talked about that probably to a lot of you guys, and we've done webinars on that as well. It's essentially the obligation of a foreigner to pay, to withhold and remit tax to IRS on the sale of this real estate. The obligation, interestingly enough, lays with the person who buys the property. So technically, your buyer, it becomes, in IRS's eyes, withholding agent, because it's your buyer who's paying money to the seller. Your buyer is supposed to withhold. Again, really quick on the FIRPTA rules. The rule starts with the fact that the withholding is at 15% of gross proceeds. So whatever is your contract price you agreed on, $1 million, $500,000, gross contract price, the withholding applies on that. So the seller is, so the buyer is withholding and they're remitting. Now, in reality, who's doing the actual withholding and remitting is the agent doing the closing. It's not the actual buyer who's, and we've had some situations where, we've heard that, yeah, the buyer actually did withhold. There was, it was in a different state. I've never heard it in Florida, but, they remitted and they actually sent money to IRS, which is funny enough. But here, when you're at a closing table and you've got, a buyer and then you've got a foreign seller, the withholding agent, so a title company or an attorney, will withhold on the closing statement, and there's paperwork that needs to go with that withholding to tell IRS that this withholding belongs to this transaction and this is how it's calculated, and that paperwork goes to IRS. So there's a couple of different choices here on the withholding. Number one, the rule is to say you withhold, and you withhold you start at 15%. So the withholding is at 15% of that gross proceeds. You can get that percentage reduced depending on the sales price of the property, and also depending on whether that property is being purchased as a primary residence of the buyer or another investment property. So there's a couple of decision tree situations, and I'm not sure I want to get into that here. I can, if you guys have questions, you can email me, but the idea is that there's withholding. It's either 15% or it's 10% on the reduced price. So if now you've got the withholding. So now you've got this foreigner who's selling the property and they're freaking out about having to send 15%. So there's a choice. The choice is something called withholding certificate application. And essentially that tells IRS that the seller says, hey, I bought it for $1 million and now I'm selling it for 800,000. So actually I don't have a gain. Because I have a loss, or even if I had a gain, I wouldn't have 15% of proceeds as my tax. Can you please excuse me and not make me send in all of that withholding at the time of closing? So that withholding certificate application is a way to ask for that 15% to not go to IRS. While the withholding certificate application is being processed by IRS, the money still has to sit with the escrow, with typically, again, it's the closing agent, it's going to be the attorney. You guys have to be very careful. Again, speaking to, from the agent standpoint, you may have a seller who's foreign and you say, oh, I just heard from a CPA that, you can apply to have for this withholding certificate application, and you actually don't have to send 15% to IRS. So we can maybe do that. Let's talk to a CPA. Sometimes if you go to a title company, the title company does not have a way to hold that money in escrow. So some title companies do, but before we run happy and go and do all of that paperwork for the withholding certificate application, we always need to know whether the title company that's going to be doing the closing can hold that 15% of proceeds in escrow while IRS is doing the application. Last year, especially during COVID, so typically IRS takes about 2 to 3 months, normally in good times, to review these applications and say, yes, you're right, you don't owe us this money, the money can be released. Once they approve it, the agent can then release the withholding to, back to the seller. But like I said, in the past, they would take 2 to 3 months. But in COVID year, starting last year, it took about a year for the withholding certificate application to be approved. So you've got this escrow agent, this closing attorney who's holding money. Most of the lawyers have a trust or escrow account anyway, and they're able to hold escrow for, there's no specific amount of time. But we came across several times where the closing was done by a title company who can hold escrow sometimes, but they did not want to hold escrow for longer than a certain period of time, which of course was completely impossible to predict how long IRS was going to take. So we kind of ran across that last year, and we ended up just advising the non-resident to just remit the 15% at the time of closing. So just very important I want to mention on the timing of this. So whether you're doing the application to not have the withholding remitted to IRS, or whether you've decided to go ahead and remit the withholding to IRS, you have a very limited time to do this. The application to not have to send withholding in has to be done no later than the closing. And it always is very stressful because the information you need to send that application in, sometimes you don't have until other pieces that are needed for closing come together. It's typically in the last week before the closing that the withholding certificate actually all comes together properly and you can submit that. But the key there is that you cannot submit the withholding certificate after the closing. It has to go no later than the closing date. It's got to be, postmarked certified mail. If you're submitting money to IRS, that 15% withholding, you've got 20 days from the day of closing to send in that money. If you don't send money in within 20 days of closing, and then you send it in late, there's big late penalties. Here's what also happens, because remember what I told you about the buyer actually being considered in IRS's eyes the withholding agent, because it's the buyer who's taking money and paying to the seller. The one who gets hit with the penalties is a buyer, because they were technically the agent and they should have withheld and remitted, and it was done late. So the buyer here, they have this beautiful property and they're really happy, and all of a sudden they get slapped with the IRS letter to say that this withholding was submitted late, and it just creates this big rigmarole. So when we're helping let's say it's a closing that we do in-house, or we're helping other attorneys with the FERPTA paperwork, we always try and be very, very diligent on the time and we try to start the process as early as possible to ask for information. So again, if you as a realtor, if you are dealing with the seller, or even you're dealing with a buyer who's buying from a foreign seller, and you hear FERPTA and you hear withholding and you hear 15%, that is the time for them to talk to a CPA, because we can start to advise them early on whether a withholding certificate for them is a good idea, or whether they actually should just remit the money to IRS. A couple of things that go into our decision, it's the timing of transaction. Like I said, if you send this application to IRS to ask them not to withhold this 15%, and they take so long to process, if your transaction is at the end of the year and it's November, December, you might as well send money in, because in 3 months you're turning around and you're doing a tax return, and that's the time for you to claim that overpayment back. So sometimes you're able to get that money back faster on the tax return than waiting for the withholding certificate application to get approved. So timing often goes into consideration. Again, if these individuals did not have an ITIN, then it becomes more difficult, because you've got to do the ITIN application. So sometimes it's just easier to remit the 15%, wait for the tax return, and then get that money back. So this brings, coming back to my point earlier about okay, we've got our foreigner who never had this property rented. Now they're selling this personal use property. Now we have the withholding. Let's say we decided to do the withholding certificate application. The closing happens, withholding certificate and the ITIN application at that time goes all to IRS. IRS takes forever to approve it. IRS sends an approval letter. So what happens too is, if they apply for ITIN at the time of the withholding certificate application, IRS first processes the ITIN, then having the ITIN, they process the withholding certificate application. So it can take longer for the whole process. And like I said, in my experience in the past year, it's been a full year. For a minute, it was going a little bit faster, but the last few transactions we've gotten back have really been a year. So let's say they apply, the withholding certificate goes in, they get an ITIN. IRS says, hey, we approve, you actually don't need to remit your 15%, because you're right, you didn't have the gain. At that point, the escrow agent can, with that letter in hand, can refund whatever that 15% that was sitting in their escrow account back to the seller. And then the seller gets their cash. We always advise to still go ahead and file a tax return, even though, again, there's no gain and the withholding has been refunded directly to the seller. But we still recommend filing a tax return, because we think that it's just your way to report the transaction of the sale of that real property in the U.S. So you file a tax return. Now you've got your ITIN, remember, because they needed to issue you ITIN for you to deal with this withholding certificate. It's easy enough. You just say that, hey, here's my transaction. I did not have a gain, and I already got my money back, so thank you. And that's kind of your first and final tax return in the U.S., and off you go. So now let's say we have a situation where they're selling a rental. So the only thing that is different here is we're watching for those cumulative losses from past years. So if I am handling a tax filing or FERPTA paperwork for a foreigner who has had tax returns done in the past, and I really am looking at their cumulative rental losses in order to really properly calculate their gain. So now I filed a final tax return in US. I report the transaction. If the money was withheld and remitted to IRS as withholding, anything after the real tax that's calculated on the gain, now we're sitting and waiting for the refund from IRS. If there was withholding certificate application and that was approved, the money came back to the individual directly from the escrow agent, then there's nothing else that they need to wait from the IRS. But that tax return for the one that was renting a property just gets a little bit more complex because you got to track all of those items on the rental schedule, including the losses. So that again brings me kind of to the conclusion of this buying, holding, renting, and selling that I wanted to mention. Cassidy, I guess Joanne is still with her appointment. She must have gotten held up. Let me take a peek at some of the questions here, and maybe if you guys want to put some more questions in chat, I can take some questions. And Cassidy, if you had any questions in the email, that's probably a good time to pick them up.
Okay, I know a lot of people are asking for your contact information. If you want to put that in the chat for them as well.
Yeah, absolutely. Yeah. All right, that's my direct email. So you can go ahead and distribute that to Cassidy if you want. People are asking for recorded video. Yes, please. AJ was asking about the withholding and whether it was 30% of gross before expenses. AJ, that is correct. So if the default is when this property manager is going to be paying the non-resident the rent, is without the election that this rental property is treated as income from a business in US, they're required to withhold 30% of the gross rent. So but what happens though is that basically meets the non-resident's obligation to IRS because they already took all this money from their gross rents and then they don't really even have to file. The other thing is if there's no ITIN, then until the ITIN is assigned, the property manager is also required to withhold. Once the ITIN is assigned, and then the foreigner can then do that election form to say, hey, please don't withhold that 30% of my gross revenue. I am just going to treat this as my rental business. Then that withholding that was done prior to ITIN being received can be used on the tax return and get that back as a refund. So I think that's all of this can get a little bit tricky, and there's definitely a lot of misinformation. And like I said, the way the times are with how behind IRS is and can sometimes alter our advice, particularly when it comes to this FERPTA issue of, we heard that we can get this money refunded to us. Sure, but maybe now it's not so advisable if IRS is taking so long to process it. Maybe it's faster to send money in and then get it back on the tax return. Let's see, phone number. Yes, I will. Put my phone number here too.
Someone asked if you have a Spanish speaker in your office. Do you have someone in your office that speaks Spanish?
Joanne is fluent in Spanish, but I'm not sure. She's fluent in Spanish, but I'm not sure that she would want to do like a consult when it comes to tax terminology in Spanish. We always suggest that if somebody does not speak English, is that they do bring an interpreter with them. If you are, as a realtor, if you speak Spanish and these are your clients and you can communicate with them, if you feel comfortable being there for consult and they give you the okay to kind of communicate with us, sometimes that's very, very helpful. Oh, Joanne came in at a perfect time. Do you speak
Sorry.
Spanish? That's all that's needed.
Sí, hablo español. It came in handy earlier today.
Yes, you did. But I just, put our email address and the phone number in the chat, and somebody was asking whether there's a Spanish speaking person, and I said, you are, but I'm not sure you want to do a tax consult or a FERPTA consult in Spanish for
I like to do reservations and restaurants and hotels
and travel tips.
The travel tips. Follow my travel tips.
But yeah, as a realtor, we always encourage you guys, if you're the one communicating with your client, that you can be an interpreter if they're okay with discussing the tax things or legal things at the consult. So Joanne, I just finished discussing the sale and touched on the FERPTA, and we talked about the rental versus non-rental. So that sort of
Did we talk about the LLCs for the rentals?
Well, I did not, so you can use this time. Yes.
In the nick of time.
Mm-hmm.
One thing that I do see with some frequency is discussion surrounding whether or not you should have an LLC for clients that are not U.S. residents. And I would submit to you that it, on the one hand, like a good lawyer, it depends. It depends on where they're coming from. So there are certain countries where LLC is preferred and favorable and fine. Specifically Canada, the LLC can cause a problem with how it's taxed for them back at home. So we try to avoid LLCs for Canadian clients. But for example, for the UK, it's perfectly fine for us to use an LLC. So the LLC is going to give them that liability protection. And sometimes people say, well, I'm overseas, so it's hard to get me from a creditor standpoint. That may be true. The other thing that people might want to look into LLCs or certain types of trusts for is if they're trying to be cognizant of estate planning tools. The estate planning numbers, tax rates and exemptions are not nearly as generous for U.S. non-residents as they are for U.S. residents for tax purposes. So we have to be careful about that. It's really going to depend on what the client's pain point is or what their concerns are. So if I have property that's being sold to 83-year-old Canadians, I have a different conversation than 40-year-olds that are planning to come for holiday once a year or something like that. So is it a rental? Is it primarily for their use? That really is a bigger conversation than today, but I just wanted to put that bug in the ear. Don't just run out to Sunbiz and start forming LLCs, because while they are fantastic, it depends on where people are from and a global tax picture on whether or not that's actually the right entity for them.
Joanne, do they need to have an ITIN in order to form an LLC?
Not to form the LLC. It is a little bit more of a painstaking process to get the EIN for the LLC if you don't have an ITIN, but it is doable. What's really tough is bank accounts. If you're trying to collect rent and need a U.S. bank account without an ITIN, that can be problematic. It didn't used to be so problematic in days gone by, but we're seeing in more and more banks that are giving people trouble with that.
Do they need to have an ITIN then? So I guess if they go to open a bank account, is it advisable now that do you find that those rules have also changed on the banking side?
Those rules are very much different now, and almost every bank is requiring an ITIN and an in-person opening of that bank account. It used to be, like for my Brits, they could go to HSBC at home, and that seems to have varying levels of success at this point. So if you can find a bank that is international, like HSBC, sometimes you can get your account opened. But most of the banks now, most of the US-based banks want to see a US address and an ITIN in order to open an account. Even when I can show them that the US address will be the property we're about to close on, that they're sending me money specifically for the purpose of buying this property that they will be using. Still, I have some trouble getting US banks to cooperate. I'm not saying it's impossible. I'm just saying ask a lot of questions before you head down that path. And for some people, that is easier with the LLC than with an individual account.
Can you mention a few words about being able to borrow money as a foreigner in U.S.?
Oh, yes. So that has two avenues. The foreign national loans are available. Typically, you're looking at about a 70% loan to value, so 30% down. If it will be a rental, that might be 35% down. Let me say this, though. If you have folks who are buying because they're going to be moving here, getting E2 visa and staying in the U.S., they are going to want to do a foreign national loan before they come, get their visa and get set up, because it will take them about 2 years to establish credit in the US, and they are no longer eligible for a foreign national loan once they establish their US residency. So people can end up getting snagged where they rent longer than they anticipated because they can't qualify for the loan, because even though they had great strong financials back home and great credit back home, a lot of those reporting agencies don't flow over to the US. And so if they don't get a foreign national loan before they get their E2 visa and establish their residency, they may find themselves renting for a couple of years. And some people are really mad about that. So those interest rates are a little higher than what you will see for us as Americans, but they're still relatively low given the market. So.
Yeah.
This bag of tricks that's fun and not fun at the same time. The other thing that you're seeing with that is then they get the benefit of playing the currency exchange. So you can not cash out and come to US if your currency rate is not favorable. It'll allow you to have more buying power and also to play the market on those currency exchange rates.
I also mentioned about the FERPTA processing times taking about a year for the withholding certificate application now.
Yeah, just file a tax return. That's what we've been doing.
Yep.
I hate to say that because it sounds like you don't want to help, and I don't mean it that way, but it's really tough to get them processed and processed properly. We get a lot of notices. I'm fighting one right now. Actually, I have a Zoom call at 3 o'clock with the client who, is still getting notices saying that there's penalties and interest and late fees, but it's false. They've cashed the check and I've sent them a copy of it at least 10 times.
And it particularly is because Joe and I talked a little bit about the difference between the individuals who've never rented the property, so they've never had to have an ITIN until the time they get to sell. So when you submit the withholding certificate application with the ITIN, they first process ITIN and then they process the withholding certificate application. So if each one of those things takes several months, you can be looking for excess of a year to get your money back. Yeah. And so that definitely makes a difference whether it was already a rental and you had already been in the system and you've got your ITIN in and things like that. So at least there's one piece of things for IRS to process. But we have in the last year, we just said, just file a tax, remit the money at closing, file a tax return and get whatever excess over the actual tax that you owe back. That way it's going to be much faster.
Absolutely.
Which much faster is a relative term, but
yeah, much faster in IRS land, which is not Usain Bolt faster. No. Do not think about Olympics when you think about IRS processing times.
Aside from all this non-resident stuff, just to give you guys an idea, we had to call IRS about a client and just talking to them about, the length of time that everything takes. And we respond to various types of notices. And they said that it takes them about 6 to 8 months to open correspondence. Not to read what this is why Joanne, your guy is not getting his answer, because it's 6 to 8 months for them to open an envelope, to read what you have to say. And then, of course, by the time somebody looks at it, can be much later. In the meantime, if this is the type of notice that's automated, so every 30 days, the penalty interest clicks. And if it's a mistake, it's every 30-day reminder of their mistake. It just keeps going. It scares people, especially foreigners, because, it's IRS and what can be scarier than that. But it really is now, nobody's just reading the notices, nobody's reading any of that stuff. So just
no one's reading anything. I saw in one of the realtor groups on Facebook, someone saying like, these people didn't read this part of the contract. I was like, no one's reading anything. Like, Never mind contracts for hundreds of thousands of dollars. No one's reading anything. No one's reading an email at this point. It's really insane, let alone the IRS.
It's gotten that bad. Yeah.
Yeah, the IRS has lost interest. They're still. I spoke to a gentleman working an I-10 unit a few months ago, and he was like, we're still on shared. They're not allowed to. They've always had shared resources. Like, you would work a different shift than me, and we would share a computer. And he was like, they ordered this other lady a computer, my counterpart a computer, like 2 months ago. She still doesn't have the computer, so she just can't work because they're not allowed to touch the same computer now after COVID. So, first it's got to come in. There's computer chip shortage, whatever. Like, it's basically they're never coming back to work. It's, if you thought it was bad before, wait till you get a look at now. But who it really scares are the practitioners that are trying to navigate. And give you guys good advice and say, look, this is a reasonable time frame to expect. Like, I can tell you based on the experience, but the experience that I have is that it's taking 12 months because 12 months ago I submitted something and I'm just now hearing about it. But in 16 months I may not hear back from today. I don't know. It might be 6, it might be 16, and kind of doing the best you can to make those estimates. So a dose of patience when it's time to deal with the IRS is in order.
For that. Any other last questions, Cassidy? I sort of monitored our chat and I feel like we had responded. Joanne, I sent out our links to our website and our address, phone number, and my email address. So definitely, if you have any questions or need clarification,
we're happy to help. Yeah, thank you.
Marie is asking about the I-10 help. I do have a certified acceptance agent that I work with, and we can assist. Like I said, the situation depends if they're here, if they're overseas, but whatever it is, I have somebody that I work with that I can get you connected, Maria. Awesome.
Thanks,
Looks
guys.
like people paid attention and listened.
Yay! To a tax talk. Who'd have thought? Perfect. All right, guys. If you need us, let us know.
Thank you.
Thank you. Bye.